Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake. Dati mihi Anglican for service of you.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I got plenty of sleep last night. There's something about sleeping in your own bed that is just wonderful. I love Holiday Inn Express. You treated me right. The food was great. The price was excellent. But my own bed, there's no place like home, right? There's no place like home. We are back home again. Finally. All right, congratulations to Britta All, our first in chat today. Britta, congratulations. It's been a bit, but you're back. You're back. We're all standing. Oh, you need to be seated. Huh. Hang on. I forgot I had to set up the seats. Let me just pause everything right now and set up the seats for you. There, I did. You're good. Well, you should. There you go. Now it's good. It's working. All these details that I forget about when I'm away from the studio. Good morning. I hope you guys had a absolutely wonderful. Oh my goodness, the seats just fill up just suddenly, just like that. Boom. Hope you had a absolutely wonderful evening and a good night. We were on late last night with a little bit of snarky commentary, which I just let loose a little bit. It was something about that road trip that just got into me. I spent a lot of time on the road and finally out of the car and back in the studio, and it felt good. And I decided to just share some of my quieter thoughts that I keep to myself generally about a particular witness, and that was fun. All right. Oh my goodness! It was. Here we are today. We're on. What is this? Is this day 22? 22, I think. Hope it's 22. I know it's...
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. Yeah. You get to ride in the back through that next trip as well. Well, thank you. Oh, my goodness. We are halfway through the work week. We made it. It's a good thing we have water. From Deer Park, not a sponsor. Every hump day, yes, I warn you guys. Not sure why my camera is trying to make this an Only Cam's Feet show, but we fixed it. Jerky did a number on it. Oh my goodness, Lallyson, that jerky is hot. It is smoking hot. It is so good though. This package will last me forever because it's not opened. The other one that is opened will also last me forever because I've only been able to eat, I think, 6 pieces of it, and it burns. It burns. Will there be cross today? I hope so, because I think that the defense is going to be 6 foot 5 inches out of 10, says Greeners. Thank you. Stonehouses is like, I didn't come here for this. Yes, it's great. Let's see. We've got one more thing before we start watching court, which is going to start. It started late today, but it's going to start in just a few minutes. We have to celebrate some birthdays. We have a few people to celebrate whose names are on the screen now. Shelly, Kelly, Jedi Jen, and Creative Beat. This is Debbie. Debbie's son Maxwell, Presley, Chastity. Is it Chastity Happiest? Oh my goodness. Okay. Oh, never mind. And Chassis. So happiest of birthdays to Amber. You do this to me on purpose, right? You do this to me on purpose. You know I can't read very well. We're just going to celebrate the ones that are highlighted here on the screen. All right, here we go. Everyone, wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. There we go. We're going to sing happy birthday to Shelly, Kelly, Jenna, Jen, Maxwell, Presley, and Chastity. Happy birthday to you. Happy birthday to you. Happy birthday to Shelly, Kelly, Jenna, Jen, Maxwell, Presley, and Chastity. Happy birthday to you. His conduct says, I paid for singing lessons to be able to hold a note like you. I gave up because apparently I only sing fantastic with my home or car. Try the shower. The shower works as well. The shower is great. Shelly, Kelly, Jenna, Jen, Creative Beats, Debbie's son, Maxwell. Presley, who is 16, sweet 16 today. And Chastity, happy birthday. There are many wonderful days, but today's your special day. Your very special day. Thank you, because there are a million places you could have celebrated and a million people you could have celebrated with, but you chose to be here with us. And the privilege, the pleasure, the honor, the joy is ours. Hopefully you can turn some of that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's. Oh, I thought that was the drum solo. McDonald's, we said Waffle House, Village Inn, we got those ones. Andy Dunlap's, not Andy Dunlap's, Andy's Bar and Grill, Bob Evans, Tammy Dunlap's house, and I guess Cracker Barrel does it too. So why not throw Cracker Barrel on there? If they're open, I'm sure you'll get a free stack. Tell them I said it was okay. Happy birthday. Free pancakes all around. Oh, let's see. Barb says, I've been a Recovery Addict member for 5 months. Barb, congratulations. I'm excited about today. It's gonna be so good. It's gonna be so good. It's going to be wonderful. Malin Law, hello, 18 months. 18 months, memberversary today. Cheryl Ann, Reasonable Doubt, member for 20 months. Happy Hump Day, 20 months for me, OG. And the KD214, member for 16 months with Ari and crew. Here's to another 16. If you listen carefully, you'll hear the cue. That's the drum cue. That lets us know we're going to do a drum solo to finish out this rendition of the birthday song this morning. So everyone, grab your air drum sticks, sit down with your air drum set, and finish it off in style with me here. Go something like this. Beautiful, beautiful, beautiful. We're all going to be pros. Basically expert level drummers, all of us, by the time this is over. Has there ever been a day that you've not had any birthdays? Amanda, there's been a couple we've had to stretch out the still accepting nominations time. And we've reached a little deep into the barrel, so to speak, to find a relative of someone who we could sing to. But we've always had a birthday. Sherry B, the tax lady, says, hey, I'm here live. I'm forever on rewatch. Sherry B, welcome. Something about being past April 15th gives you more time in your day, I'm guessing. But that's just a guess. Kelly, member for 22 months, says, almost to my pink courthouse. Let's go. Speaking of courthouse, let's go to court here. We're going to start in just a moment. All right. Meatballs and Mayhem, good to have you here. Love the name, by the way. That's a wonderful name. How do you register your birthday? Vivian, there is a form that we link to occasionally in chat. You'll see the mods put it out there. You can post your birthday anytime you want. So if your birthday was, let's say, Christmas Day, you could put yourself on the list right now for your birthday on Christmas. We'll save it. We don't whitewash the form and start over. It's not like a whiteboard we erase for the day, but there's the form. Samantha, thank you very much for putting that up. There's the form. You can put your birthday. We don't want all your information, so just put your birthday, your mother's maiden name, the last 4 digits of your social security number, and your last 3 addresses, and that's all we need. No, just kidding. Don't give us that. Don't. That would be terrible. Just your birthday, no year, is all we need, and that's it. Amber, one of our great mods here, member for 26 months. Know anyone hiring a remote employee? I'm in the market. No place I'd rather be. Can't wait for 2025 end of year awards. It's been a wild year already. I'm guessing we got some recent submissions. We do a Festivus celebration at the end of year and celebrate some of the high or low points of the channel at that time, and it's a lot of fun. Amber puts a ton of work into that, so help her out if you got some nominations. Catherine, member for 16 months. Good morning, RA mods and friends. Good morning, Catherine. Good morning. Greener says aperture. Negative. That's a negative. I'm going to celebrate my girl's day of birth. Geez, 16 years is wild. Megan, that is awesome. 16. You've got a teenager. I mean, not just a teenager who probably can drive. Oh my goodness, there's a bug in my studio. Hold please, I can see it. Where did it go? I go out of town. I go out of town for 1 week, and the bugs think they can come in my house. Like to give a quick shout out to Southern Febreze, who is not sponsored this show, but could. Hear ye, hear ye, hear ye. Southern Febreze. This is lavender scented Southern Febreze. Just did its job on a little bug that was trying to climb up the window. My next home will not be built in 1915. I can tell you that. Oh my goodness. Matt Daddy P says, what just happened? Matt, I live in the South. And one thing we have in the South is they call them water bugs.
I was told council wanted to see me inside bar.
I've got a scale model. It's a little smaller than the real one, but this is what they look like. It's a bit of a beast. But that's what we have that lives outside. And my home was built in 1915, so we're constantly fighting to keep the bugs out as well as the weather out. And with the bathroom remodel and drilling and everything that's going on next door as we're putting pipes and plumbing and everything in, the bugs think, hey, free access. No. I do not allow them to exist in here. So when one does get inside, Southern Febreze to the rescue, and it's fixed. It ran, like it almost got away. It got into I've got a blackout curtain so the sun doesn't blind me in the mornings, and it got underneath the blackout curtain, so I had to reach and grab the curtain. I couldn't see behind and see it. All right, we're not going to talk about the bug anymore. Let's see. Barb, they're obviously that model is much bigger than the bugs are here, but I don't like them at all. Since the rain, yeah, it has been dumping down rain here, just dumping down rain, and that's when they try to come inside the most because I guess they like to be dry. So it's the fan on 2 times speed. They have got it cranked today. When we start court, which should happen any moment now, by the way, when we start court, we're expecting to have Judge Beverly Cannoni come back with a ruling. So that's going to start the day. Come back with a little ruling on how we're going to proceed. And I can't remember off the top of my head what the ruling was about, so remind me in chat, and it will all flood back to me. My brain is thinking about a bug right now. Misconduct member for 26 months, another OG. I'm on holiday this week, so I'm free to chat. 1 ear RA, 1 ear EDB. My pub is older than your house. It's a Tudor building lot. Oh my goodness, Tudor buildings are beautiful. I know we've got some Tudor style buildings here in the U.S. Over in the UK, it's amazing. I ate dinner once with the family who lived in a Tudor style thatched roof house. I think it was Tudor style thatched roof. I think those two combinations, because it was like, I know it had a thatched roof, but I think it was Tudor as well. And I love the white and the brown and the cross patterns and everything. It's just it's beautiful. And the idea of just a roof made out of grass, other than the fire danger, is really, really cool. Does Mrs. R.A. have tips on how to make banana bread if your bananas are a little too fresh? That's actually the best time to make it. If you try to make, well, when you say too fresh, are you saying are they too yellow or are they too brown? When they're too brown, it makes better banana bread. Too yellow does not work. So I would put your bananas in a paper bag, and they will ripen very quickly. Like close them up in a paper bag. You check on them like every 2 minutes, because just like that, boom, It's like, whoa, that was quick. Paper bag works every time. Too yellow. Yeah, you sort of need to wait. A good solution, Tisha, is to plan ahead and keep a couple bananas, at least one batch worth of bananas in the freezer, ready to be thawed out and used. Nicole's here. Instead of Southern Febreze, I'm partial to a flamethrower. Actually, Southern Febreze can work as a flamethrower, though not intended by the manufacturer. Ask me how I know. John Davenport, member for 26 months. John, my friend, I'm here for all the sounds of Recovery Addict in the morning. A bug, spray, where did it go? It's rushing me. I hope I got it. That was it. Jackie, is it Jackie or Jackie? Asked earlier, when JOK exited the car, would he not have stepped onto the sidewalk? That would mean that witnesses from yesterday's measurements would be wrong. Do they have a sidewalk? I don't recall there being a sidewalk. Oh, yes, there was. There was a sidewalk. Good question. But also remember one witness, I'm trying to remember which one, testified that when they looked at the snow, they saw tire tracks in the snow. And there shouldn't have been any tire tracks in the snow. Dog Lover says, can I get some positive vibes? I've been to the dentist I'm going to the dentist for a root canal. I think I'm close to dying. Oh my goodness. Dog Lover, the only positive vibes I can send your way are the ones that go bzzz when they drill. Hopefully you don't feel any of that. Been there, my friend. That's no fun. Lee, you're fired. Just for the record, there's nothing on the wall behind me. One day that's going to happen. I'm just going to have to delete my YouTube channel. There'll be a bug that's like up the wall. I'll just be like delete, start over. Go with a faceless channel, I guess, next time. Melissa P. says, before I have to go, I'm going to say it one more time. We really enjoyed Snarky RA. There was a lot of snark. Some of that was just pent up from a long trip on the road in rainy conditions. The street is dark. There's only a single light on the street, and it's not near the flagpole. There's no sidewalk on that side of the street. Brennan tried to trick the snowplow guy with that question. Mr. Pancake, nope. I was trying to imitate a dentist drill. Love Rob's clip of RH chasing a bug. That will haunt me for the rest of my life. Oh, here we go. I was told counsel wanted to see me at sidebar. We have a ruling first off.
All right. Good morning, everybody. All right, so...
That's a big sigh. We're counting it.
Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology.
Are you kidding?
The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up. We should have them momentarily.
Where did you copy and paste that from?
Thank you for the late call.
Okay. Is Dr. Welcher right around?
Yes.
Why don't we bring him in if he's here before the jurors?
Wow. I think it was 2 sighs. Let me go ahead and count those from the judge this morning as she gave the ruling about Dr. Welcher's comments. Because they didn't object to the lack of scientific method, he can testify as an expert that his non-scientific method reached that.
Data version, we provided a copy to the defense.
Wow.
With all the redactions.
Okay. Are you in agreement with this, Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement. So
Okay.
I can just go with the way it is.
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
Do you know the number?
Okay,
You don't have to find it if you don't.
It's 131.
I'll admit it.
Oh, is this
provisional
was
to
it 130?
redactions.
Was it 131 yesterday too?
It was.
So at sidebar, I said we could go back to that. And Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
It is, but subject to me being able to object. I was basically because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh yeah, no, I'm okay with that.
Yeah.
That one, yes, Your Honor's recollection is correct.
Yeah,
I'm okay with the heading removed.
And we were going to start on that, but you thought because I struck it based on the objection, but then at sidebar I said we could go back to that. That's your understanding too?
Correct, Your Honor.
Yeah, I'm sure that Dr. Welcher took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
I think he did as well.
I did.
Thank you very much.
Okay.
I would have liked your prediction to come true.
Are they
like your
out there, Paul?
prediction.
Okay, thank you.
Okay, I'll admit this one more page. Subject to redaction or conditional to redaction based on a ruling that you didn't make, but I think that you will. That was a crazy statement. The judge came in, I think, ready for a fight and didn't get one from Mr. Alessi. Obviously, that was a ruling, and he thanked her for it and ended. It did not go in Mr. Alessi's way. This was, I would say, a big win. I would say 2 out of 3 wins for the prosecution there, a small win for the defense, where Mr. Welch is going to be able to testify that
All persons having any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
All right, good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors.
got to ask
I
you
have
those
to
3
ask you
questions.
the same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor.
It's been a good jury. Following the rules well. Okay, we're going to go back a little bit, get those same questions in that were struck. Here's the little retreating and covering the same ground briefly.
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you 2 other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? There we go. Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is...
Oh, could you take that down, Dr. Welcher?
Yes, thank you, Mrs. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you...
So we need to take this slide down.
Sorry?
You could take the PowerPoint down, please.
I was in a different spot on the slide. Hold on a second.
Oops.
That's better.
Thank you. Sir, I had asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Just before, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my fingers.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been 2 potential theories that I've seen on that issue.
It's a yes/no question.
One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
And do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes.
What's your opinion?
That it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on side swipe collisions or clipping. Can you describe to the jury and explain what a side swipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they've landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Well,
I'm not sure I'm not covering anything.
Let me see if I can.
He's redacted part of the name. Na et al.
So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Just like the Lexus. Oh, wait, different.
Next slide, please. And what does this represent?
Okay,
so this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg.
Thank you.
The buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sure.
Do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure, John. Thank you.
I hope the family
So
gave you
to-
permission to show that. I mean,
At the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury, so no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your Honor,
pleasure.
I would move into evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson, with that
That is, Your
caveat.
Honor. Thank you.
Mr. Alessi takes a deep breath and says, "Here we go." The Lexus, the car in that crash had significant damage.
In both the flash drive and the notebook.
On representation, it's consistent with it was the same as that. I have no objection.
So let's put them both together now and decide later.
Thank
Okay.
you.
Those two slides are incorrect on the flash drive.
Yeah, that-
Okay, so we'll switch that.
that was-
Thank you.
We're on cross now. Just finishing up the
What
evidence.
exhibit number is it?
Entry of the evidence into the record.
Exhibits 206A and B.
All right, Mr. Alessi, whenever you are ready.
Your Honor, if I could have a moment to set up.
Sure.
Big sigh, we're counting it. I'm going to keep the siren counter off the screen just so we can focus on the testimony. If there's another sigh or a siren, I'll add to it. I want to stay focused on this. Start with the pleasantries.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
Any other questions for your questioner, witness?
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is accident reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. when it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yes, certainly for the court of law, yes.
It ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to a reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
In terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that
there was a dog in the fight.
Quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That
correct?
is 100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So in terms of, you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible the selection of a final hypothesis, is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm sorry, sir,
to
to interrupt you.
I need to.
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So, are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So, I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally,
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury, is how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay,
generally what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question, sir. I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct, but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you at least some
it's like they're
point,
speaking different languages.
It's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case, and then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened, so you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. Mm-hmm. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, mm-hmm. you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
That took some work. We might be here all day.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Mm-hmm. Isn't it the case that when you have multiple hypotheses, the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate.
Okay.
But there's exceptions.
Fair enough. But as a general principle,
sure.
With some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right. Based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you know...
I'm familiar with his reports. I don't know the man.
Okay. Familiar with Trooper Paul through his reports in this case, correct?
Correct.
We use the same physics.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first part of your question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So...
Actually, I might be able to find out if you'd like me to look at the documents.
It's not all that important. You would say it's within a week of September 23rd, 2000? It was in September of 2024?
I believe it was in September, yes.
Right.
I would want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
No, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're an engineering company. We bill for our time.
So you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
Checks his watch.
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
You need a new accounting department.
So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just
didn't
gave.
math, Alessi.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay. So you're aware there's a contract between Aperture and the Commonwealth.
I signed it.
And you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right, and so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing?
Correct.
Who pays for that Lexus exemplar?
Aperture.
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus, we're keeping it till the trial's over, we're selling it, and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
but they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
Okay, I don't want to speculate. I just wanted to see what the obligation was. So
the obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So
we
the
have a new
Commonwealth
high-dollar expert
is obligated to pay at least $325,000, and is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no. I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work,
that's a ton
about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture and all offices, if I showed you the contract?
Sure.
May I put you on it?
Yes.
Okay, this is a ton of money. Normally, I would say this is a silly line of questioning to pursue an expert witness.
Yeah, could you direct me so we're not wasting time?
You should be talking $10,000 or $20,000.
With the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
I have never seen a case with a company that has been on the job for as short a while as this, 8 months, and getting close to $400,000.
And then when he's done,
This is
Mr.
big
Leslie,
money.
you can take it back.
This is big money. It's a lot of money for doing the work that Trooper Paul did in the first one.
There you go.
So they paid him as well.
Can I ask a few more questions before?
Of course, he was
I
a
get, Your Honor, for
salary.
foundation purposes, if I want to do more than refresh?
All
Or
right.
would you like me to start with
So-
refresh?
Come to
Go
sidebar.
ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor. Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
No, I just signed the papers. I have no idea what they say.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mm-hmm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks? 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
That's funny.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
but he's looking now.
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
thank you. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting
Your
to
Honor,
do.
may he do that?
Yes. I'm
Now
going
you
to see
can.
counsel at sidebar while you pull that up,
Thank you,
please.
I think the judge is going to be like, "Where are you going with this? You've dug, you've got the number out, the $400,000, which is not the most anyone's ever paid, according to just a quick Google search. I mean, there are some cases that have been add an extra zero on there, but it's definitely on the high end, for an expert witness to testify in court, especially one who provides less than a year's worth of work. But Mr. Leslie focusing on the financial amount to say, looks like a dog to me. Looks like you got a dog in this fight. Looks like you got about a $300,000 dog in this fight. I think he's reading messages on his Garmin. I actually went down and slowed that down to look at that because there was a point where he stopped and looked down at his watch. And I thought, is that what I think it is? It looks like he was reading a text message on his watch or something that came in, which would be a problem. Let me show you that little bit as it came in. No sound on this one, just the video. Here he was. He's answering questions and looks down. The angle he's looking down, that's really close to his body. It's not where his hand is, so it's not where he's writing on the paper. It looks like he's looking at his watch there. I don't know. Getting hot texts during court. Text message read, "You have received $50,000 from Commonwealth of Massachusetts. Thanks for using PayPal." Evangeline Light, member for 25 months. Thank you very much. I appreciate Ari and family makes life interesting. Congratulations, Evangeline Light, member for 25 months, an OG there. Thank you. I went to sleep last night to the sounds of a screaming goat.
Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question.
Nurse for God, thank you so much.
Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Oh.
assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't interrupt.
No, I'm not sure how much granularity you want to that answer.
Great. So you created on January 30th, 2025. You made your
13th.
Pardon me?
Oh, the original one. Sorry,
Yes.
January 30th, modified May 13th.
Right. If I could finish my question, and I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right. So
that was the second half.
Got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
Who?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
Speaker, I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So, A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been in, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you not to refer to that.
I'm trying to be helpful.
Close your computer.
Let me close it. Sorry. I was trying to answer his question.
Close your computer.
Yeah, that's probably a good idea.
Just flat.
No, it's like the judge's order is what it is.
So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April.
Mid-April.
If I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right, and so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that that should be looked at? What's the basis of your understanding that he found new information?
Objections to the question.
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So,
what was the new
do
information?
you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes.
What is that?
What he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether, in fact, it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
What was the data?
Sir, Has Aperture ever submitted a report, a changed report in the middle of a trial, to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir. Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for a break or 5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess? Again, Dr. Wilkie, right behind.
Great. Love to use the restroom.
What? What did he just say? Rewind just a second here. Okay, rewind, replay. Hold, please.
All right, folks, why don't we take our morning recess? Again, Dr. Wilkie, right behind.
Great. Love to use the restroom.
Love to do the rest what?
Love to use the restroom.
Dr. Wilkie, right behind.
Great. Love to use the restroom.
What is he saying there? Love to use the restroom? I think you're right there. Maybe splash some cold water on his neck. Check his text messages with Mr. Burgess. Change his pants. I don't know. I'm just throwing things out there. It could be a lot of things. You know I've been pretty harsh on this witness, right? Especially with my little snarky video last night. I've been pretty harsh on him. I struggle because I've seen a lot of expert testimony now from a lot of different experts in a lot of different fields, and I get a different vibe with this guy. I get he has the credentials, right? He's got the degree, he's got the job, he's got the title, he's even got the work experience and the court. You know, his CV shows he's testified federal, state courts. He's done this. He is an expert. But when he talks, my brain doesn't believe that he's an expert. He summarizes all the tricky parts, all the science bits down to just say basically physics and math. Any reference to some long-standing or peer-reviewed principle that he's applied in the case is dumbed down to someone did a dissertation, or there's a paper. Some people did a paper on it. The vague references that are applied anytime science is involved scare me just a little bit. Let's see. He did get the dates right that Alessi completely butchered. Alessi came up with what? You've been on the case for 2.5 years? Like September last year till May of this year. And that's less than 2.5. I did that in my head. Mr. Alessi tried to move on. And the guy's like, wait, let me answer your question because 8 months equals less than 2.5 years. I know that. Chris Wallace gifted a membership. Thank you very much. He has all but the ethics and integrity. There's a lot of money on the line. Do you think the jury's looking at this? It's something they can consider, right? The judge is going to give them instructions saying they can consider any motive that a witness might have to be less than truthful. Do you think the money comes into play at all? $300,000 for 8 months? And the way he answered the question, it sort of left the door open that I can only speak for my office for sure. Could the other offices each have their own contract? Possibly. His words actually do not indicate conviction in his allegations. He would be called wishy-washy on a lot of stuff if the jury are interested in reading between the lines for what people say. I don't know, the part that I struggle with is there are some things, like when you start talking about a scientific method, okay, that experts, this is their bread and butter. Okay, this is how they operate. This is why they can, this is the foundation they build upon. When they talk about the scientific method and the procedures and how they can test and why they can say, I know this is right, based, to a reasonable degree of scientific certainty. It's because I followed these steps and I know that I can achieve a result with my testing that is reliable because I did X, Y, Z. His foundation is like, well, it depends. I like to just do it all in my head and mix it up and add some more hypothesis. And I'm like, okay, all right. It sounds like you like doing puzzles, is what it sounds like. And it sounds like you might even be an expert at doing puzzles. And you like to see all the evidence and shake it up and mix the pieces up and see what fits. And then once the puzzle's done, or at least you got the pieces to fit, you say, that puzzle's finished. Puzzle's finished. Because the pieces fit. That might work. And honestly, it might get him to the right conclusion in this case. That's a possibility. But some puzzles, the pieces fit in the wrong order. Some puzzles are cut specifically that require closer analysis and have to be swapped out and say, but is there another piece that makes a better fit than the one I have here? And it doesn't sound like he did any of that. He didn't do any of the challenging. It was more like, can I make the image that I think happened come together in the puzzle? And he did. Chris Ball says, ARCA was free though, correct? No. It got a little fuzzy. It started out being free, and then they ended up getting paid. So at the time, this is based on testimony. I mean, like it or not, this is what was said in court and to the judge and how things go. At the time that ARCA testified, there was no contract between the defense and ARCA for payment for their testimony. After their testimony, they invoiced the defense and said, hey, we did the service. You should pay us this. Defense paid. Initially, all their work was done at the behest of the federal government, say FBI. We can't say that in the court, but everyone knew. And they did the work, and the defense basically got the benefit of the analysis the FBI asked them to do. So the defense had not asked them to do anything other than just like, hey, show up with your paperwork and a subpoena. We'd like to talk in court. But now ARCA is definitely on the defense's payroll for their case. They only invoiced for the cost of testimony, so I think it was like $20,000 or something. I don't remember. Commonwealth is done after this witness, and we still have no concrete evidence that anyone was hit by the car. Yikes. Amber, I have told you before, I am okay with circumstantial evidence reaching a conviction. Okay, I've been on board with that before. And I still, in spite of all what I don't like about this witness, Dr. Welcher, I still think the Commonwealth has a very strong circumstantial, or just a strong case in general. I think it was presented much better than trial number one. I think defense should be worried that the jury could look at the evidence and convict Karen Reed based on what's been admitted. I agree. I think defense has some major weak points that, if exploited properly by the defense, which I think need to be investigated, I guess exploited is a bad word. Proctor is one of them, which we've gotten to a lot. And this particular witness's processes and procedure of reaching the conclusion he did is possibly another. Experts get paid before their testimony. I think they get paid after. Some get paid during. Like there'll be a, incremental billing. Like, once I reach point A, once I turn in this report, the initial report, then you pay this much. After the final report, then you pay this much. Then after, trial, then we invoice for everything else. Many defendants have been convicted on just circumstantial evidence. The Simon case was one, no body. Ashley says, you're okay with Karen Reed being convicted on this evidence? Seriously? I'm just saying that the jury, okay, we see something differently than the jury sees. We see everything from trial number one and everything that's happening outside of the case. The jury only sees what is allowed in front of them. And the jury, based on the evidence that's admitted in front of them, okay, they don't know about all the butt dials and everything else that we have major questions about. But the evidence that has been admitted in front of them thus far, I think a jury could come to the conclusion that she's guilty. Now, defense has to go first. Defense gets their turn, and they will, and that can have a huge effect on that. I've convicted people on circumstantial evidence, says J.D. DeWolf. Canton blew the entire investigation from the go. The defense is going to focus on that for their case. Arca did not destroy evidence. You talking about the taillight or the chips? Selena says, once again, why doesn't Leslie attack the evidence and the testimony, not personal attacks if he has something? I think he is attacking the evidence in this case because he's attacking the process the witness took to reach a conclusion. Right now, what he's digging on right now, this whole Mr. Burgess coming up with new information, that's new because Mr. Burgess says it was not new information. He said it was information we had before and just moved it over, just made an adjustment based on something we already knew all along. Now he's saying he met with Mr. Burgess, and Mr. Burgess said, hey, I found some new information. When? May 8th, after trial started. Found some new information. Going to make some adjustments. This is a problem. This is Mr. Burgess basically being ratted out by his coworker for potentially listening to court when he was not supposed to, when he was sequestered. That's where he's chasing, what rabbit he's chasing right now. Hang on, smiling thrifty Pam. RA, apparently, in my opinion, let's keep it with me, just me, thinks that my asking for you to not talk about the witness is reason for me to check out another chat. I've been listening and loving this community for a long time. Smiling thrifty Pam, we're welcome all different opinions. I know a lot of people disagree with me, and I disagree with a lot of people, but welcome here. We just ask that the discussion be respectful. We can learn together, and at the end of the day, we can either agree or disagree, and we can still be friends. No problems there. I can be wrong, and you can be wrong. That's how things go. Mia says, to be honest, not surprised at this money. These tech companies always get a lot of money for what they do. Remember the experts in the Maya trial? It was insane what they got. Yeah, especially Dr. Joe. Dr. Joe. Oh yeah, he got nothing. I remember. He was there on his own dime. Great guy, by the way. Let's see. If I was a Norfolk resident, I would be fine with the costs that it takes to find justice for the unnecessary death of a man and a Boston police officer. The fact of the matter is trials cost money. They do. And trials where an investigation is required, where there are questions, where it does take some investigative and even lab work, they're expensive. This retrial is not cheap by any means. I would say the retrial is much more expensive than the first one. But good stuff. I love hearing opinions that differ than mine. I do as well, especially well thought out ones that can convince me to change my mind, because I am the first person to admit that I generally I'm not the smartest person in the room, and I have something to learn from pretty much everybody I talk to. Why do you think he's taking notes? Would he be recalled after ARCA or no? Miss Joni Hockey, I think he's taking notes because Mr. Alessi is using scientific vernacular, right? His terminology, the way he's forming the questions, is leaning towards the scientific side. And this witness, whether it's, based on his education or based on his personal preference, tends to speak in more common language. And so when you get a question that comes out very scientific, I think he's writing down the parts just so he can follow it and make sure he's answering it correctly. He's already been confused, and they've sort of spoke around each other a couple of times because of that. That's why I said I think they're speaking different languages. It's like they're both talking to each other and not understanding what the other person's saying because of that difference. OG Sean White says, I'm a resident of Norfolk County. I'm embarrassed. They're retrying her. Let's see, I have 25 years in adulting with children, so does that make me an expert in parenting? Can I get paid $400,000 for 8 months of work? The pay is in the photo album. That's all you get. And the grandkids, that's pay as well. It eases mental load to jot things down like dates mentioned and whatnot. It's actually a good technique to organizing, thinking, and communication. You're right. I think when it comes to a witness on the stand, taking notes, anything they have up there on the stand they use, the prosecution and defense can basically say, show me what you got. I'd like to see it, all of it. And that's a problem, particularly for this witness who has leaned heavily on his laptop. Well, first of all, he's controlling the slideshow. He's not saying, next slide, please, right? He's got the PowerPoint pulled up. He's got his computer. He's got all the reports right there. And the judge is like, this is sort of a problem, okay? Your testimony has to be based on what's up here. And if needed, we can refresh your recollection with what's in there. But don't link the two, right? Don't link the two unless we give you permission. Was it $300,000 or $30K this witness was paid? This witness signed the contract for Aperture, and the contract has between $300,000 and $400,000 roughly. I think it's like $370,000 is the upper end limit of what the state can be billed, or the Commonwealth can be billed. Miss Justice Jones says, I'm late, but this doctor wants to argue with Alessi. His first words to introduce himself, thinking he has the upper hand on Alessi, but it didn't work. Wow. I would say that the witness is doing remarkably better than I thought he would. And part of it is because of this difference in how they communicate, the different language they use to speak about the same thing. It's making it difficult for Alessi to pin him down, partially because he doesn't seem to hold to the same standard, things like the scientific method that other experts, swear by. This is my honor. This is my, I swear by the scientific method. This is what I do. And he's like, yeah, generally, we try. We're not going to argue about semantics, and that's kept him sort of in a way sort of untouchable by Alessi. As he can't be pinned down and hemmed into a corner using some of the questioning that Mr. Alessi is good at. Witness has the same problem as me, always wanting to answer the question while testifying. Just close the computer. Let's see. He seems sketchy. Chris, I think if Mr. Alessi, even if he's not able to pin him down with some of the questions he wants to pin the witness down with, I think he would take it as a win if the overall impression of the witness was, that was sketchy. He seems, something's off there. That would be a win. That would I think, in the eyes of the jury, at least put a question mark next to some of the credibility of the witness and some of the things they came up with. I do hope, particularly, that these jurors who have been following the rules and asked every single day if they are talking to other people or listening to the news or watching social media or anything, they know they're not supposed to do that. And I think it's pretty clear that from the questions the defense has asked, that the experts aren't allowed to do that either. They're not allowed to watch and listen to what other people are saying in court. So I think they should be taking notes right now, and maybe their ears perked up and said, wait, didn't Mr. Burgess say there was no new data? And why would he have new data? Something's fishy about this, and I think it's becoming obvious that somebody broke the rules. Let's see. He's argumentative, hoping to confuse the jury. That's his goal. He wants to introduce doubt, confusion a little bit. The gruesome photo in the PowerPoint was just wrong. Oh, my goodness. Okay, he blurred out the name partially, okay? So we see part of the case where, I don't know, it was student whatever versus whoever. And then he shows a picture of a pedestrian that was killed in a car accident and blurs out the face. After saying the location and partially the name, he uses this photo. And I can see why he would want to use the photo. We have a car crash that occurred. In that case, it was 25 to 35 miles an hour, so a little bit higher speed, by up to 10 miles an hour. But similar, sort of like a corner strike or a side swipe. I'd say it was more of a glancing blow than a direct hit. No broken bones. But man, you see the car? The car was messed up. The hood was wrinkled up. There was blood and tissue on the sharp corners or the sharper edges of the vehicle where it was struck, and some pretty significant, deep, massive damage to the body, to the soft structure of the body. Let me go back. Well, we've got just a minute to a couple things. Perfectly inelastic collision. Do you remember this when he said in an elastic collision, the transfer of energy happens so that the two objects move together, they reach that common speed and continue. That type of collision is where the two objects meld together and become one. That's like two things strike and the heat of the impact or the caused by the impact fuses them together, and now the bicycle is part of the car and it continues on. I'm not sure if that's what he really meant to talk about there, but he keeps talking about side swipe. Side swipe is where the side of the car is hit, and I would say for all intents and purposes, the damage on Miss Reed's car, even though it was on the right side of the back, was on the back of the car. The only side we're talking about is the side of John O'Keefe's body. So that when he starts citing cases about side swipe accidents, let's imagine a car right here and as somebody is turning around the pedestrian and hits them with the side, get hit with a passenger door, a side swipe. He's citing side swipe situations and saying you usually don't see broken bones. You usually don't see something like that in a side swipe situation. That would be perfectly common. Side swipe in a car accident is a different terminology than what we're talking about here in this car accident. Let's see. When one vehicle loves each other, another vehicle very much. Yes. That's a topic for another day and another channel. Didn't he say 2 broken ribs and liver lacerations? Mammy, are you talking about John O'Keefe? We've got testimony that the broken ribs on John O'Keefe is an injury, especially where they were located and the type of injuries on the ribs are consistent with that life-saving pneumatic device. That's it's a powered plunger that's put on the chest and just pumps on the body and just continues CPR. Does not tire, does not stop, keeps the rhythm going, and often breaks ribs. Let's see. Could they switch attorneys during a cross, or does the same attorney have to finish up? That would be switching riders mid-course, like midstream, and generally not allowed. Barring some strange, unforeseen circumstance, illness, sickness, death in the family, family emergency type thing, I usually no. Usually only one attorney can cross and one attorney can ask on direct. In some situations, the judge might allow there to be a little bit of a a separation. I think we've seen once before where I think it was on direct. A particular witness was questioned about two separate sections of testimony, and they bifurcated the direct. But that's very, very rare. And I think you'd probably need to get the agreement of the other side before you could do that. The victim, the gruesome one, he presented about broken bones and a liver laceration. I didn't see the broken bones on the chart. Of course, I was busy trying to get the chart off the screen. All right. That was the Ashley Benefield case where we did that. It seems familiar. I know we watched it here. Was it Cruyff? Cruyff's legacy? Those disagreeing with Alessi's approach lack the awareness to realize they're guilty of exactly what it's explaining. If you've made your mind up already, guess what? That's confirmation bias. I know that jurors are instructed not to think about the case or not to discuss it, not even amongst them, in their own head, not even to think it over until then. I don't know how well that works in application.
Call from Jen Christie. To accept.
Jen Christie, this is RA. How are you doing? Sorry, let me turn the phone volume up.
I'm good. How are you?
I'm doing great. What's on your mind? We've got just a minute before we come back from court here.
I know, which is why I called, because I only want like a second and I'll talk forever. I just wanted to, because I missed the beginning, which is fine, and I don't need to catch up. I just wanted to know, did you have a good time when you went to Idaho or Utah or something?
I'm going to Idaho for Bear Lake the end of January. But this was a short road trip just to the middle of the country. We're not disclosing where. We went as far as Nashville and then a little on.
Did you have a good time?
It was a blast. We drove 1,100 miles, went to a little community pool, swam for an hour, went back to the hotel, got up, and went back home. So that was it. Looks like they're coming back from court, though. Thank you very much for checking in. We'll see you.
All right, have a good whatever. Drink.
Bye.
All right,
okay,
bye.
Bye. All right, we're back. They're not allowed to talk about it amongst themselves because they are not supposed to form an opinion before all the evidence is in.
All right, whenever you're ready, Mr. Alessi.
Thank you, Your Honor. And if I could please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
Closed, yes.
Would he open?
So did you just turn it off?
No, but I will. I closed it. You want the computer all the way off, or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at sidebar,
Sure.
please.
Why did he open up the computer? Okay. That is not very expert-y, right? It's not very expert-ish to keep doing that. The judge just told him not to do that, but he's nervous. I see that. And honestly, I would be more nervous. I would not do as well as he does. I would especially not be able to remember dates, times, anything else. I would not be a better witness than this guy. I'm not saying that. But I still think that as an expert, he can be held to a higher standard.
Lunch break, I'll ask you to remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break, okay? Thank you.
He has multiple monitors.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day.
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job, and I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going on. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes.
Did he see his watch?
EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just asking a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
I'm going to keep this audio going, but I want to show you
The
what this
text
watch
stream
looks
data
like.
indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time. If you're saying associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis, or anyone's analysis, in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events that are...
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
It's going to be
Are you
sustained.
saying there's no basis for the question?
Yes,
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
Okay.
So the objection sustained. You need a foundation, Mr. Lessie.
It was sustained.
Sir, as
She was just
part
waiting for the
of
question.
your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir, that there were do you recall that there was a report of Trooper Paul?
Yes.
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No. I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report,
Of course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
The objection is you are aware the Commonwealth has said, thinks this. I'm just looking at this. Going back to his watch thing, I think this is a text message. This is clearly a text message on his phone, on his watch, that has appeared here. It is a Garmin style watch. He's told us about that already. It matches. It's the white on black. Hang on one second. Okay. My kids are working on the bathroom here. We're going to zoom in one more time and show you the watch on the screen. There's not a lot I can do to make it clearer. This is the closest. He got a text message, and this pops up. This is on the screen. If we back up a little bit, let me show you what happened just briefly before this, and why this might be pulled up on his wrist. Let's back up here. I need to go back to this one right here, to the POI. There we go. Watch this. That moment here, if we watch that in slow motion, he's clearly looking at his watch, okay? Because look at his right shoulder, or excuse me, his left shoulder comes up because he's lifted his arm into a viewing position. He's looked down at his watch and back up. The shoulder comes up just on that one side. Yeah, this is backwards. So in actual time, it was very quick. It was this fast in actual time. But yeah, anyway. He's getting messages on his phone, on his watch. It's his wife saying, sit up straight, you're slouching. I don't know. And the reflection in his glasses, I looked at that, I couldn't read it. It's the angle's bad for that. I did actually look at the reflection in the glasses. There's no indication that it's harmful. It could be, I mean, I get messages all the time that don't have to do with what we're doing right now. From, even from people who, followers of the channel might text me about something completely unrelated in the middle of court that we're watching. I'm not on the witness stand, but I do check my messages fairly regularly. You've got a Canva. I have not checked that one yet. Red, I need to look at that. You do a great job with those. His wife sending spicy messages. He's cheating on his math quiz. Texting him the math answers. 8 months is less than 2.5 years. Got it. So the line of questioning that Mr. Alessi is following right now has to do with the key cycles. And this can be confusing. But basically, think of a key cycle as every time you put the key in and turn it on until you turn it off. That's one cycle. It's possible that a key cycle can be put in, turned to accessory power, not started, and turned off. That can also be a key cycle. It doesn't have to necessarily start the engine, is my understanding. But that's a key cycle. Every time that happens, it goes to the next key cycle. He's questioning about a specific number. I think it was 1162, 1167. I don't remember. There are a couple issues. First of all, on his chart, during that key cycle, they're only showing 4 events that happened, when in fact there were 10. Things the car logged occurred from power on to power off. So that's one issue. The other one is he's trying to get to this, and he's trying to say, are you aware that the Commonwealth, up until the beginning of this trial, said that key cycle happened while they had possession of the car? That was them. That was them moving the car, not Karen Reed. He's not getting there so far, and I'm not sure if he's laid enough foundation to get the question in the way he wants. But it sure caught him off guard when he's like, "What? They had the car during this? This is the accident time. This is the accident time." Commonwealth says it was in their possession. So that was the gotcha moment. Should we take bets on whether he has the watch when he gets back on the stand? No, and I think it's terrible that people are texting him. I think it's also terrible that he lists his personal number on his website. Okay. There are lots of terrible things going on here. Don't bring the watch to court. Yeah. If he doesn't get it in this way, they will get all of Trooper Paul's report through with their own witness anyway. I'm not sure how much will be admissible of Trooper Paul's report. The Commonwealth didn't use it in their testimony. I mean, how much can you say? Oh, you say that now, because that would be the story, right? You say that now to the court that this is what your theory of events was, but before you used to say this. Doesn't matter. What they're saying now is what the jury has to decide. So unless it's for impeachment of a witness, I just don't see it coming in. It does appear that the jury is leaving, and it could be for, well, let's see, 12:15 early lunch? Or do we have another voir dire? Could it be another voir dire? A child can't even wear a Fitbit at school when taking tests. It's early lunch for sure. I don't think food would be ready yet. There's no way they would know that this break is coming right now. Who's attacking the witness? Don't attack the witness. Welcher just confirmed he read Trooper Paul's report as part of the evidence collection. He therefore had this key cycle data, and the defense expert will therefore be allowed to use it. He says he didn't base his decisions on it, though. So relevance is going to be fairly low. It'll have to pass that hurdle first. Stonehouses, we're putting up the gypsum board in the bathroom right now. Well, the boys are. I had them stop because they're banging with a hammer, and I don't want to, during the break, we don't want a lot of noise. Made up his own ridiculous conclusions. I don't think they're ridiculous. I mean, I think the process he used to get to them was not the scientific method. I think it was puzzle building, and it is a logical conclusion based on some of the evidence. So I think it was a little much to say that based to a degree of scientific certainty, a high degree of scientific certainty that this is exactly what happened. I think that's a little much, but I don't think it's unreasonable. Here we go. Where are we at? Sidebar's over. Leslie's going to continue. Talks with the tech guy. Says, I'm going to have you zoom in right there. That's where we're going next. Checks with Karen Reed. Says, you tell him.
May I, Your Honor?
Sounds like he
Thank
has
you.
to move on.
Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Hold on, Mr. Leslie. The court reporter can't hear you.
Thank you. I will.
Thank you. I'll object again to the question that's coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that sentence.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
The judge is going to write out the question for Mr. Alessi because he cannot seem to get by the objection, and I think it has to do with the idea that the Commonwealth has a theory about this, and he wants to ask about the Commonwealth's theory. It might have to be something as simple as were you asked to look at multiple times as possible, moments of impact. I don't think he's going to be able to get in that part where he's saying he basically wants to say to the jury, last time the Commonwealth thought it was a different key cycle. That's what he wants in, right? Last time the Commonwealth says it was a different key cycle. It wasn't this one, it was something else. I don't know if he'll be able to get there. I don't think the judge, Mr. Brennan, would probably object to the judge wording the question for him in the format that would get around the objection. But I think Mr. Alessi is a smart man. If he understands what the objection is clearly, he should be able to rephrase the question in a way that will get close to it. It could be rigorous, but it still has to be allowed, and that question's not allowed. And she's given him a lot of chances. Mr. Brennan wants an objection, wants a instruction read. The judge says we're not there yet. Jury is present. They have heard all these questions, so I think they know where this is going. Bring up the watch. I don't think there's any solid evidence that the watch has been used to influence his testimony anyway. He just has been getting messages during his testimony. And he, like me, likes his tech and leans on it periodically. long sidebar for this issue. I don't think the judge is going to allow many more attempts at this. Yeah, his question after the sidebar ended last time was, Judge, may I? Absolutely terrible question. Objectionable just on to the form of the question because it was compound, if nothing else. I'm responsible for the speculation and new conspiracy theory. I'm just showing you what I observe. Normally, a witness would not be allowed to read messages on their watch or phone during court, and he did. Thanks, Shanks. The defense is not impressing the jury. The problem is, if this is their last witness, which we think it was, it's not a big finish. It's going to depend on rebuttal and a strong closing to leave a good impression in the minds of the jury. But this testimony at the end is sort of fizzling a little bit, although it does have a little pizzazz. John says, I personally wouldn't have the ability to manipulate my watch to answer questions while testifying. Anyone who's been on the stand understands how much attention needs to be paid. John, I hear you, but we've literally watched this witness while being asked an in-depth and lengthy question from Mr. Brennan, flipping through pages and looking at things and perusing some of the documents he brought, all... and then when Mr. Brennan asks the question, basically answering a different question that he wasn't listening to. So I think this witness is prone to doing that. All right, Miss Little left the room. We're headed to the back. We're bringing more papers up. Mr. Yannetti is back. His job's done. The boys have this one. Karen Reed is not up there. Can he ask, are you aware of any theories of the Commonwealth? I don't know. That part of the question seems to be the one part that has been consistent with every question that was objected to and sustained. Every time he gets a question that has some aspect of the Commonwealth's theory leading up to this point, it's been sustained. So I think he has to take that part out. He doesn't want to, because that's the part he wants in. I don't know how useful it would be as a member of the jury to know that the Commonwealth said, look at these key cycles and tell us when this happened. I mean, it could have been here, it could have been here. That's why you have an expert. Okay? This is technical data. I would not hold that against the Commonwealth if they said, we've looked at the data and we think it happened either here or here. Send it to an expert. Tell us what you think. I don't know where Mr. Lussey's end goal is with that particular line of questioning, but if it ends just that, if it's just that fact that the Commonwealth didn't know which key cycle was right, and they previously thought that a key cycle that he is using as the accident key cycle was considered to be in their custody, I don't think it's a huge point. This is where Brennan needs to be really careful with ARCA. They might bring out on their cross that their work has changed in response to changing Commonwealth theories. I thought that the ARCA report stayed the same, that it hasn't changed. And they're not, and the ARCA is now being used as rebuttal to the Commonwealth. So they literally are responsible for responding to whatever the Commonwealth has changed. ARCA added 12 new opinions. That's a lot. Mr. Welcher would have run out of fingers trying to name those. Cindy says exactly, he was just trying to prove something wrong, something inconsequential. The difference is there was a huge jump in key cycles when Paul got it. The accident key cycle was 36 cycles less than the one they stated. Excuse me. What number was it? 37.
May I, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
Is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need you?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
You did.
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did.
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So, you know how to, do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion.
Getting the calculator.
And the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We need to do, if we're going to do that, we need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
here.
right.
So I just want to get the principles down first.
He whips out the TI-89.
Newton's second law force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. An object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured.
Right.
In the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you take, usually acceleration is measured in feet per second squared. If you divide it by 1 G, which is 32.174 feet per second squared, that gives it to you in G's. People have often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1 G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
yes,
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry?
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds, and then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation and that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No.
Okay.
Just want to get to the... That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did... Can I ask another question?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next question.
Can I go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you. So I'll repeat my question, and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay. So doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on direct?
I thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you contest that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities?
Hey, that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus, has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way. Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
He's not rattling this witness.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
That was my word.
Fair enough. We'll call it a spoiler.
How did you learn that word?
You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I would use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height, you did all that?
Yep.
Where was it? It was you? Was it you in that slide?
It was.
Where were your feet?
On the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground, to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler, because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe, at the time of impact, had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented it to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applying assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Alessi, why don't we break here?
Thank you, Your Honor.
Okay. So, jurors, your lunches are here. We'll see you.
Please rise for the jury.
Goodbye.
Goodbye. Tell you, I'm surprised. I thought Mr. Alessi would get under the skin more of Dr. Welcher, and Dr. Welcher has held his own under cross-examination. Part of it is because Dr. Welcher is not letting Mr. Alessi ask the questions the way Mr. Alessi wants to ask them, whether it's through intentionally answering differently or anticipating the direction of the question and trying to answer that instead. It's breaking up Mr. Alessi's flow of questioning. And instead, we've got a couple moments where the mic drop has gone to Dr. Welcher with a, yeah, I think I did mention that actually. And you know, I think he has held his own. I think he's doing well. I know Mr. Alessi is going to save the best to last, and so I think there's some more areas that we're going to go into here. But as everyone has pretty much cleared out the courtroom, just a couple people remaining. It is it's time for lunch. That's what it is. Debbie, Dr. Welcher believes what he presented is factual. He is standing by it. The only time I got a reaction saw a reaction from him was when he's like, it was done properly. He's like, this is silly that you're asking me this. He believes it's done properly. But interesting witness. I'd say, yeah, I'd say he's performing better than many experts under this level of scrutiny. But he's not done. There's more to go. The idea that Mr. Alessi said we're going to move on from this issue, the one that we took to the sidebar several times, trying to ask about the Commonwealth's belief or theory about the key cycles. It says we're going to get back to that later. It sounds like the judge or one side or the other wanted more time to present an argument to the judge about that. And so the judge might have a decision yet to make about whether or not that was relevant or how we could tie that in. That could be what the work the other lawyers are doing to try to make that work out. But I do hope we get back to the key cycle thing and try to get that hammered down, because that was interesting. Better than Burgess, I would agree 100%. This is the smarter man of the two. They need a break for lunch. Alessi needs to regroup. He does. I think Alessi thought it would be an easier task to rattle this witness than it is turned out to be, and I think he's still up for it. But yeah. Truth is subjective. Is that what he said? Truth was subjective. Yeah. All right. We are on. We're on day 22. So I need to get to. Did she say how long lunch was? Did anybody say? I think we're coming back at 1:45. Might come back just a tiny bit earlier if we have time. But lunches are short here, so we can't stay and talk too long. We will do an automatic portal over to the afternoon live stream where we're going to follow along. I will keep the replay machine up and handy. If any more incidents occur that we have to watch in slow motion, say for instance, the fan. We can see the fan and slow it down, and see it in slow motion if needed, backwards or forwards. But there's more interesting stuff than the fan to watch. But we'll keep an eye out for that. I did get a couple texts from somebody who has some pictures of the Garmin watch showing that screen we saw does in fact match the layout of what a message appears to be when a message comes into a Garmin watch. So it looks like you did get a text from someone Just not sure who or if it has anything to do with this case, but always good fun to look into that. Okay, there's 145. We have the new thumbnail up. There we go, just looking for the right button. We knew it was going to be spicy, and so far it has not disappointed. So more spice incoming for sure, as we expect to hear the words, "The prosecution rests," very soon, either today or tomorrow at the latest. Veritas, welcome. Good to have you here. The fake thumbnail. Okay, I'll check it on lunch and see if we can pull it up. Red, send me the link again. I think you invited me, but I have to. Oh, wait. I think I'm already in. I have to just switch to your account. Switch teams. Now send me the invite again. I can't seem to find the team link. You guys, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again after lunch in about 30 minutes, roughly. I've got a sneeze. The sneeze wants to come, but it won't happen, so we'll just do it. Portal isn't coming. We'll bring you all over to the afternoon session. As soon as shortly before the afternoon session starts, we'll jump to it and we'll follow all the action throughout the stay in court. We're going to finish this cross-examination. We're going to see if Alessi gets where he wants to go with this witness, which means rattle him and make the jury not believe him. But he's got a ways to go for that one. This is turning out to be a tough project. You guys have a good one. We'll see you after lunch. Bye-bye.